From the 651 Carpet, home of the Next Day Install Studios, Twin Cities News Talk. My name is John Justice. Minnesota Supreme Court overturning a Court of Appeals decision. The state's high court examined whether or not a woman simply exposing her breast constitutes conduct of a sexual nature. Female breasts are not lewd or inherently sexual and can be exposed in public, according to the Minnesota Supreme Court. We're going to talk with lawyer extraordinaire Jeff O'Brien here in just a moment. First off, get to a few of your thoughts from the iHeartRadio app this morning.
John, I just opened up our pool yesterday. We're going to the pool company today to get the correct chemicals. It sounds like this might be a very interesting year around the pool. You have a great day.
Well, around the pool, around the protests, pride festivals, I mean, the list goes on and on.
Good morning, guys. It's Joe up in Blaine. Well, John, this ruling by the Supreme Court is going to make the state fair a little more interesting for the news crews doing their live shots, especially on those extremely hot and humid days. Well, it'll be fun. Have a good day.
Hey, morning, John. You know, this whole Supreme Court thing with the topless women, can we just have a real honest conversation here? If women don't come out in force and, blast this idea and how ridiculous it is, I'm going to have a hard time not watching.
And I'll stop it here. And this is kind of the point that I wanted to get into. So the origins of Minnesota's law dates back to 1885 when the legislature incorporated elements of a New York penal code into state law. The New York law was based on English common law, which defined lewdness as the irregular indulgence of lust or other sexually oriented behavior that is indecent or offensive in a public place. Justice Carl Procaccini wrote that because lust and indecency are ambiguous terms, often left to the eye of the beholder, lewd behavior in Minnesota legal statutes refers to conduct of a sexual nature. What the woman here at the center of this case, Eloisa Plancart's conduct, was it of a sexual nature? The Supreme Court ruled it was not. So joining us to help work through all of this is lawyer extraordinaire Jeff O'Brien. Good morning, sir. How are you?
Good morning. I'm good.
So I'm hung up on this definition here of conduct of a sexual nature because you've got two elements here. You have the perception of somebody when they see a potential topless woman, and then you have the intent of the topless woman herself. Are we just assuming here that the ramifications of her exposure on another individual simply do not constitute a sexual nature because that's on the observer?
I think that's what they're getting at. I've been trying to go through this opinion and trying to figure out what the heck they were thinking. You know, it was the part of the defense was this was an equal protection claim. So I guess part of the argument is if dudes are allowed to walk around with their shirts off, so women should be able to too. And to that, I would say I wouldn't mind having a law that would make most dudes cover themselves up. I got a next door neighbor that likes to mow with his shirt off, and I would prefer to legally be obligated to put that back on. But it's just. You and I talked off air yesterday. I don't see how a woman having her breast exposed isn't somehow of a sexual nature. But, we already have an exception in the law for breastfeeding. So I really don't understand where this is going unless what was suggested is if this is because of, other public demonstrations or something like that we're trying to prevent these criminal charges when people do this. But, I guess we're furthering the boundaries of free expression in this state.
So Justice Hennessy, in the concurring opinion, wrote that clarifying whether a female breasts or private parts could provide concrete guidance for law enforcement and promote consistent non-discriminatory application of the law. Okay. And it seemed as if that would have been the case if we had deemed that a woman exposing her breasts was deemed just lewd. I mean, those are private parts, and that was deemed to be indecent exposure, essentially. Her opinion determined that multiple dictionary definitions clearly show that private parts refer to genitals, which Hennessy notes are a person's reproductive or excretory organs, and breasts do not fall under those categories. It seems like they're getting into like very specific black and white issues while ignoring the societal norm aspect of this. And the way and the difference between viewing a man with his shirt off versus viewing a woman with her shirt off. And I know you wanted to talk there, Jeff, so I'll let you go ahead and continue.
All I'm going to say, we're going to dictionary definitions of private parts and all this kind of stuff. This is what happens when you have too much education. I mean, seriously, they are absolutely overthinking this, in my opinion. It's just more. It's more bizarre rulings out of that court. But at this point, with a 100% DFL court, what do we expect?
Yeah, and I'm actually really glad that you worded it that way, and it kind of makes me feel a little bit better about where my head was at, because I was thinking the same thing. It's like, you guys are really overthinking this. I mean, the mere fact that the case in and of itself, the woman said that she did this because that's how Catholic girls do it, but she subsequently said that she was a stripper at a biker bar. I mean, that would, in and of itself, in my view, almost demonstrate the rationale for why she exposed herself in the first place, in which case that could be interpreted easily as sexual activity, or that being the motivation here. And maybe you're correct in that this just really speaks more to the makeup of our far left extremist Minnesota Supreme Court than it does anything relating to common sense on this particular issue.
Yeah, we'll see where the fallout comes from this, but yeah, I agree. This one is a head scratcher for me.
Just as importantly, let me get back to a few more things here. Talking with lawyer extraordinaire Jeff O'Brien. She pointed out to... Well, let me back up here a little bit. Because the state law makes a separate category within the indecent exposure statute for breastfeeding, it would seem that the legislature wanted to differentiate between a woman exposing her breast for that reason versus exposing them in general. She pointed to a separate legal statute around the dissemination of non-consensual images, which clarifies the difference between private parts and intimate parts. And just as importantly, Hennessy wrote, interpreting private parts to include female and not male breasts would lead to the continued stigmatization of female breasts as inherently sexual and reinforce the sexual objectification of women. So I think when you get further into the details here, you begin to see the real motivation here as to why they would have rolled this way. At least that's the way that I'm interpreting this, Jeff.
Yeah, I see where they're making an equal protection argument, that if basically that they're going to look at the private parts definition as kind of a universal definition, like you said. We're looking at reproductive organs. Both males and females have them, but this is different, right? Interestingly enough, there seem to be pointing out differentiations between men and women, but that's neither here nor there. But yeah, I think that's what this comes down to. They basically said, what's good for the goose is good for the gander.
And I'll add one more thing into this in terms of motivation, right? While she agreed with the decision in Plancart's case, Hennessy worried that future cases around women having their breasts exposed in public may not be so clear because people can disagree about what constitutes conduct of sexual nature. And that's kind of the point that I was making earlier. And then she also wondered about the exposed chest of a transgender man or a transgender woman who's had top surgery, or the exposed chest of a breast cancer survivor who has had a mastectomy. And you know what, Jeff O'Brien? Brian, I'm just going to go back to what you said a moment ago. I think they really are just overthinking this. I really think that's what this comes down to. Do you expect this will be challenged?
I don't think it'll be challenged in terms of people coming up with other ways to push the boundaries on this, probably.
Yeah.
But in terms of the decision standing, I mean, it's the state Supreme Court. What is anybody going to do?
Right. Let me go here. I know we weren't going to talk about this, but I'll just get your quick sort of instinctive reaction. Liz Collin posted this yesterday. The Minnesota State Bar Association is hosting a race and equity series about Derek Chauvin's trial. She writes, you'll see some familiar faces, but you won't see any evidence that race played a role in the arrest and, as she writes here, the heart attack of George Floyd. One of the sessions is Remembrance and Recollections from the Courtroom, the Derek Chauvin trial. This is the first of a series to bring direct insight from judges and prosecutors of the trial, discussing the implications, process, conviction, and community impact 5 years later. I mean, we had a conversation recently on the show, Jeff O'Brien, just about the state of the Bar Association. This race and equity series would seem to be falling along the same lines of what you and I discussed about a month or so back.
Yeah, and I can say this generally for those that don't know. So, it's lawyers in this state, we have continuing education requirements, continuing legal education, CLE requirements. We have to get so many credits through a certain time period. And besides general credits, we have ethics credits that are required during that time period, as well as what they call elimination of bias credits. And they have now a new one with like mental health or wellness or something. But this elimination of bias requirement, these kinds of programs are what are put up to satisfy these requirements. So ironically, there is an inherent bias in the types of programs that are designed to satisfy this requirement. You have to get approval from the board to be able to, the CLE board to offer these. There used to be one. The Federal Society used to one called Bias What Bias. That one went away about 20 years ago. They wouldn't let it have it anymore. It was very controversial. But that's probably where this is coming from. But I agree with Liz. I mean, there's definitely race implications in that whole, in the trial and the conviction and everything else, and it should be explored. But it's unfortunate because we as lawyers you think of some of the famous stories about lawyers. We're supposed to take on controversy. We're not supposed to be a popularity contest, and we're supposed to deal with uncomfortable questions. And so I think it's a missed opportunity that isn't being discussed there.
One more quick thing that rolled in regarding the Minnesota Supreme Court decision here, and I'll kind of readjust it based off of the talkback that came in from a friend of the show. But she laid out this scenario for the lawyer extraordinaire. Say you're at the Minnesota State Fair and you're a woman and you're walking around without your top on. If somebody comes in contact with you, I mean, is it now akin to, say, grabbing a woman on the arm? If this is not, if these are now no longer private parts, is this no longer assault if somebody were to come in contact with this exposed body part? Do you see a potential where that could go and cause a problem or an issue?
No, I absolutely can predict that is going to happen someplace, and we're going to have more cases on this issue because of this decision. Absolutely.
Lawyer extraordinaire Jeff O'Brien. I had to throw the signal up. Very short notice, but I thank you for answering the call, and I look forward to talking to you again in the near future.
Well, sounds good. Thanks, John.